Hello, everyone, and welcome to Internet Law Review. For today's story, we're going to talk about the dismissal of the criminal charges against actor Kevin Spacey. And the way that they got dismissed was actually somewhat dramatic. The lead accuser, and pretty much the only person who witnessed the crime, the person who was molested during a preliminary hearing, pleaded the fifth as to questions regarding his potential manipulation of evidence on his cell phone, evidence that may have exonerated Kevin Spacey. Because he pleaded the fifth, his entire testimony was stricken from the record, and because there was no testimony indicating that this event occurred, the case was dismissed with prejudice, which means that this criminal case is dead and cannot be brought back. So we're going to read a little bit about what happened in this case to try to highlight it and talk a little bit about due process issues. Let's get started. So, this article from ABC News notes that the decision to drop charges followed a meeting between the accuser's parents and prosecutors, in which the alleged victim exercised his Fifth Amendment rights against self incrimination during a preliminary hearing, in which he was testifying about a missing cell phone. The complaining witness was informed if he chooses to invoke his Fifth Amendment right, the case would not go forward, which he did, and therefore could not go forward. So the story behind the missing cell phone itself is pretty interesting. The police collected the cell phone of the complaining witness in order to do forensics examination and other examination of the text message records. And then, at least according to the police, they gave it back to the victim's father. The victim's father said that they never received it, and the police unfortunately did not get a receipt signed by them when they returned it. So there's no evidence in the record to say that it was returned, but the police testified that they had returned it. The cell phone was important because it might have contained exonerating evidence. As this article from ABC News goes on to say, over the course of the hearings, it emerged that the mother of Spacey's accuser had deleted potentially exculpatory data from the cell phone before turning it over to police, and the lead investigator in the case didn't file a report saying the mother's voluntary admission until just last month, more than 3 years after the alleged encounter. So there's a couple problems there. When a person testifies or gives evidence to the police that they may have deleted records, that evidence is considered Brady material. It's able to be used by the defense to potentially impeach the credibility of the witness. Now, the mother of this person did testify at this preliminary hearing, and she said that she deleted evidence of her son using, consuming, or possessing marijuana or other drugs, but didn't touch the text messages in question. Of course, that may well be true. Maybe that is exactly what happened, but the defense is entitled to that information because they have a right to cross examine and explore for themselves whether or not that is truly the limit of what happened. As the article goes on to specify, when the defense team learned of the developments, they sought from the judge and were granted direct access to the phone so they could conduct their own forensic examination at their own expense using their own experts or otherwise gain information that might contradict the state's evidence. And this secondary examination proved to be useful. The defense attorneys were able to find evidence that key parts of the conversation had been deleted from the phone before the phone was turned over to investigation, which is also potentially a criminal act because you're talking about destruction of evidence. The article goes on to note that during questioning from the defense attorney, a recess was called after the accuser was asked whether he was aware it's a crime to delete potentially exculpatory data from a piece of evidence in criminal probe. Yeah, it would be destruction of evidence would be the crime. And he said that he was not aware of that, which, fair enough, I suppose. Apparently, based on this, the accuser then said that he was going to invoke his Fifth Amendment right to accusation. So, of course, every person has a right not to incriminate themselves, and that includes witnesses to crimes. So, if you are asked a question and you would be prejudiced by giving an answer, you don't have to answer. Now, if the question is proper and you plead the fifth, then the only remedy is to strike the testimony completely. Because if it's a valid area of exploration and the defense has every right to ask the question because they have due process issues too. Of course, we'll never know for sure why the accuser chose to plead the fifth or what crimes he was concerned about. He has the right to keep that information secret, so we can only speculate. Perhaps he was concerned about destruction of evidence charges, but I have a sneaking suspicion that the prosecutor told them that if that was the only issue, that they would give him an immunity, which the prosecutor has a right to do. So they'd say that, if the only crime that you're concerned about is this destruction of evidence, just testify truthfully, we'll give you immunity, and then you have no Fifth Amendment issue. Fifth Amendment only applies if there's a criminal prosecution or possibility of one, and the government can give you immunity to wipe that issue away. So I suspect that's what they said, and the fact that they didn't jump on that makes me wonder about some of the other issues. Perhaps they were concerned about drug use issues. The mother had testified that there was evidence of marijuana, and at least the defense thought there was evidence of cocaine, although the mother denied it. And perhaps they would have asked about that as well on the stand. Although I would again think that the prosecutor said that if you're talking about small recreational amounts, again, we can give you an immunity waiver for that. Even with an immunity waiver, of course, the defense would have every right to ask questions about it and bring it up as character evidence or other evidence as they explore what messages were and were not deleted. But this person who was the accuser had his own lawyer, and he was given plenty of time to make the decision. From the time he initially invoked the fifth until the case was dismissed was a full week. So I'm sure that his lawyer worked over any issues with him and perhaps even had some conversations with the prosecutor in a more discreet way about trying to get some sort of immunity protection. But I guess ultimately they weren't able to get there. So just a quick case to show the importance of due process concerns and why confessions from a defendant are always helpful, because you never know in a criminal trial when a witness might fall apart on the stand or even before that, because this was preliminary hearing. And that's what happened. So case dismissed with prejudice. Kevin Spacey will not face any more criminal charges. The civil suit, of course, was also dismissed. And that's it for now. But until later, my friends, I hope you're well. Cheers and goodbye.